Welcome to SNS Academy. I am Satyanarayana Saha. Good evening, students. We are discussing Indian Polity by M. Laxmikanth, 7th edition. I have uploaded up to chapter 6 videos. There we cover historical background of the Constitution, making of the Constitution, salient features of the Constitution, concept of the Constitution, preamble of the Constitution, union and its territory. If you have not seen, then you after that you watch those videos. It help you for connectivity. So today we discuss about chapter 7, citizenship, नागरिकता. फर्स्ट दिया गया है मीनिंग एंड सिग्निफिकेंस. Like any other modern state, India has two kinds of people, citizens and aliens. Citizens are full member of the Indian society and owe allegiance to it. They enjoy all civil and political rights. Aliens, on the other hand, are the citizens of some other state and hence don't enjoy all the civil and political rights. They are of two categories, friendly aliens or enemy aliens. Friendly aliens are the subjects of those countries that have cordial relations with India. Enemy aliens, on the other hand, are the subjects of that country that is at war with India. They enjoy lesser rights than the friendly aliens. They don't enjoy protection against arrest and detention. Article 22. तो इस पैराग्राफ में दिया गया है इंडियन सिटीजन को, इंडियन पीपुल को दो भाग में बांटा गया है, सिटीजन्स और एलियंस. सिटीजन्स उसी को बोलते हैं जो कि इंडिया का हर सिविल और पॉलिटिकल राइट्स को एंजॉय करता है. लेकिन एलियंस वो सिविल और पॉलिटिकल राइट को एंजॉय नहीं कर पाता है. और दो टाइप का एलियंस है. एक तो फ्रेंडली एलियंस. फ्रेंडली एलियंस इसको बोला जाता है जिस कंट्री का साथ हम लोग का अच्छा रिलेशन है और जिस कंट्री का साथ लड़ाई झगड़ा ये सब होता है वो एनिमी एलियंस बोला जाता है. सो इसको याद रखने के लिए इंडियंस दो भाग में बांटा गया है, सिटीजन्स और एलियंस. एलियंस दो भाग में बांटा गया है, फ्रेंडली एलियंस और एनिमी एलियंस. The Constitution confers the following rights and privileges on the citizens of India. ये दिया गया है फंडामेंटल राइट्स का ऊपर, जैसे राइट अगेंस्ट डिस्क्रिमिनेशन ऑन ग्राउंड्स ऑफ रिलीजन, रेस, कास्ट, सेक्स और प्लेस ऑफ बर्थ. यह है आर्टिकल 15. आर्टिकल 15 बोला जाता है जो डिस्क्रिमिनेशन नहीं होना चाहिए रिलीजन, रेस, कास्ट, सेक्स और प्लेस ऑफ बर्थ के आधार पर. राइट टू इक्वालिटी अपॉर्चुनिटी इन द मैटर ऑफ पब्लिक एम्प्लॉयमेंट. यह है आर्टिकल 16. राइट टू फ्रीडम ऑफ स्पीच एंड एक्सप्रेशन, असेंबली, एसोसिएशन, मूवमेंट, रेसिडेंस एंड प्रोफेशन. यह है आर्टिकल 19. कल्चरल एंड एजुकेशनल राइट्स. यह है आर्टिकल 29 एंड 30. Right to vote in election to the Lok Sabha and State Legislative Assembly. Right to contest for membership of the Parliament and the State Legislature. Eligibility to hold certain public offices, that is President of India, Vice President of India, Judges of the Supreme Court and the High Courts, Governor of States, Attorney General of India and Advocate General of states. Along with the above rights, the citizens also owe certain duties towards the Indian state, as for example, paying tax, respecting the national flag and national anthem, defending the country, and so on. In India, both citizens by birth as well as naturalized citizens are eligible for the office of president, while in USA, only a citizen by birth and not a naturalized citizen is eligible for the office of president. तो यहाँ पर लिखा गया है राइट्स और ड्यूटीज़, ये दोनों सिटीजन्स का पास है। जैसे राइट्स वो लोगों का पास रहता है तो ड्यूटीज भी रहता है, जिस तरह टैक्स पे करना, नेशनल फ्लैग, नेशनल एंथम को सम्मान देना, ये सब ड्यूटीज है। और जैसे बाय बर्थ और नेचुरलाइज सिटीजन, ये सब एलिजिबल है प्रेसिडेंट, प्राइम मिनिस्टर होने के लिए, लेकिन यूएसए में ये फैसिलिटी नहीं है। वहाँ पर ओनली ए सिटीजन बाय बर्थ एंड नेचुरलाइज सिटीजन एंड नॉट ए नेचुरलाइज सिटीजन, नेचुरलाइज सिटीजन वो वहाँ का प्रेसिडेंट नहीं हो सकता है। आफ्टर दैट सिंगल सिटीजनशिप, इंडिया सिंगल सिटीजनशिप फॉलो करता है। जिस तरह अमेरिका, वहाँ पर 2 टाइप का सिटीजनशिप फॉलो होता है, जैसे जोन सा स्टेट वहीं का एक और अमेरिका का एक। Though the Indian constitution is federal and envisages a dual polity, it provides for only a single citizenship, that is the Indian citizenship. The citizens in India owe allegiance only to the Union. There is no separate state citizenship. The other federal states like USA and Australia, on the other hand, adopted the system of double citizenship. इंडिया में ओनली एक तो सिटीजनशिप फॉलो होता है, जो कि पंजाब, हरियाणा हो या उड़ीसा हो, जहीं पर भी एक आदमी हो सकता है, लेकिन वो इंडियन कहलाएगा, वो सिर्फ इंडियन सिटीजनशिप उसको मिलेगा। In USA, each person is not only a citizen of USA, but also of the particular state to which he/she belongs. Thus, he/she owes allegiance to both and enjoys dual set of rights. One set conferred by the national government and another by the state government. This system creates the problems of discrimination, that is, a state may discriminate in favor of its citizens in matters like right to vote, right to hold public office, right to practice professions and so on. यूएसए में 2 तरह का सिटीजन है, वो यूएसए का एक तो सिटीजन है और एक स्टेट का सिटीजन है जहाँ पर वो रहता है। उसमें प्रॉब्लम आता है, डिस्क्रिमिनेशन का प्रॉब्लम आता है। इन मैटर्स ऑफ राइट टू वोट, राइट टू होल्ड पब्लिक ऑफिसेस, वोट देना और पब्लिक ऑफिस में रहना, ये सब प्रोफेशन चूज करना, ये सब में प्रॉब्लम आता है। दिस प्रॉब्लम इज अवॉइडेड इन द सिस्टम ऑफ सिंगल सिटीजनशिप प्रिवेलेंट इन इंडिया, जो कि इंडिया में प्रचलित है। सिंगल सिटीजनशिप में वो प्रॉब्लम नहीं होता है। इन इंडिया ऑल सिटीजन्स इरेस्पेक्टिव ऑफ द स्टेट इन which they are born or reside enjoy the same political and civil rights of citizenship all over the country, and no discrimination is made between them. However, this general rule or of absence of discrimination is subject to some exception. यहाँ पर जौन सा भी स्टेट में वो पैदा हो, लेकिन उसको एक ही सिटीजनशिप का दरवाज़ा मिलता है। The Parliament under Article 16 can prescribe residence within a state or union territory as condition for certain employments or appointments in that state or union territory or local authority or other authority within the state or union territory. Accordingly, the parliament enacted the public employment जो कि requirement to एच to residents Act 1957 and thereby authorized the government of India to prescribe residential qualifications only for appointment to non-gazetted posts in Andhra Pradesh, Himachal Pradesh, Manipur and Tripura. As this act expired in 1974, there is no such provision for any state except Andhra Pradesh and Telangana. The Constitution under Article 15 prohibits discrimination against any citizen on grounds of religion, race, caste, sex, or place of birth, and not on the ground of residence. This means that the state can provide special benefits or give preference to its residents in matters that don't come within the purview of the rights given by the Constitution to the Indian citizens. For example, a state may offer concession in fees for education to its residents. जो द कॉन्स्टिट्यूशन जो कि आर्टिकल 15 में बोला गया है वो प्रोटेस्ट करता है क्या डिस्क्रिमिनेशन जोन सा रिलीजन का ग्राउंड है रेस कास्ट सेक्स और प्लेस ऑफ बर्थ द स्टेट कैन प्रोवाइड वो प्रोवाइड करता है स्पेशल बेनिफिट्स और गिव प्रीफरेंस टू इट्स रेसिडेंट्स in matter that don't come within the purview of the rights given by the Constitution of the Indian citizens. और एक स्टेट ऑफर करता है कॉन्सेशंस एजुकेशन और रेसिडेंट्स के लिए. द फ्रीडम ऑफ मूवमेंट एंड रेसिडेंस जो आदमी जहीं पर भी जोन सा भी स्टेट में जा सकता है रह सकता है इज सब्जेक्टेड टू द protection of interest of any scheduled tribe. In other words, the right of outsiders to enter, reside and settle in tribal areas is restricted. Of course, this is done to protect the distinctive culture, language, customs and manners of scheduled tribes and to safeguard their traditional vocation and property against exploitation. Till 2019, the legislature of the erstwhile state of Jammu and Kashmir was empowered to Jammu Kashmir को empower किया गया define the person who are permanent residents of the state and वहाँ पर देखा गया कौन सा किसका किसका permanent residence है confer any special rights and privilege on such permanent residents as respects employment under the state government के अंडर में एम्प्लॉयमेंट कैसे मिले एक्विजिशन ऑफ इमूवेबल प्रॉपर्टी इन द स्टेट सेटलमेंट इन द स्टेट में सेटलमेंट हो एंड राइट टू स्कॉलरशिप एंड सच अदर फॉर्म्स ऑफ एड प्रोवाइडेड बाय द स्टेट गवर्नमेंट द एबव प्रोविजंस वाज बेस्ड ऑन आर्टिकल 35A of the Constitution of India. This article was inserted in the Constitution by the Constitution Application to Jammu and Kashmir Order 1954. This order was issued, ये order issue किया गया by the President under Article 370 of the Constitution which has provided a special status to the erstwhile state of Jammu and Kashmir. Jammu and Kashmir में जो आदमी रहते थे उन लोगों को स्पेशल राइट दिया जाता था लेकिन 370 को हटाया दिया गया. अभी जम्मू एंड कश्मीर एक यूनियन टेरिटरी है. टू द erstwhile स्टेट ऑफ जम्मू एंड कश्मीर इन 2019 द स्पेशल स्टेटस वाज abolished by a new presidential order known as the Constitution Application to Jammu and Kashmir Order 2019. This order suspended the earlier 1954 order. The Constitution of India, like that of Canada, has introduced the system of single citizenship and provided uniform rights for the people of India to promote the feelings of fraternity and unity among them and to build an integrated Indian nation. Despite this, India has been witnessing the communal riots, class conflicts, caste wars, linguistic clashes, and ethnic disputes. Thus, the cherished goal of the founding father and the constitution maker to build an united and integrated Indian nation has been fully realized. जो कॉन्स्टिट्यूशन मेकर लोग का मेन मकसद रहा है कि यूनिटी बजाय रहे और सभी एक स्पिरिट को रियलाइज करें, जैसे सिंगल सिटीजनशिप। कॉन्स्टिट्यूशनल प्रोविजन क्या रहा है? द कॉन्स्टिट्यूशन deals with the citizenship from Article 5 to 11. Under Part 2, however, it contains neither any permanent nor any elaborate provisions in this regard. It only identifies the person who becomes citizen of India at its commencement on January 26, 1950. It doesn't deal with the problems of acquisition or loss of citizenship. Subsequent to its commencement, it empowers the Parliament to enact a law to provide for such matters and any other matters relating to citizenship. According the Parliament has enacted the Citizenship Act, which has been amended from time to time. तो कॉन्स्टिट्यूशन जो डील करता है वो 5 to 11 और वो पार्ट 2 में कंटेंट रहता है। चैप्टर 7 में याद रखोगे 7 आर्टिकल है। 7 आर्टिकल क्या? 5 से 11 तक, और ये सेकंड पार्ट ऑफ द कॉन्स्टिट्यूशन है। यहाँ पर डील किया गया है, क्या मुख्य विषय है? नागरिकता मुख्य विषय है, सिटीजनशिप का मुख्य विषय है। अकॉर्डिंग टू द कॉन्स्टिट्यूशन, द फॉलोइंग 4 कैटेगरीज ऑफ पर्सन्स बिकेम द सिटीजन ऑफ इंडिया at its commencement on January 26, 1950. हम लोग का संविधान कार्यकारी हुआ 26 जनवरी 1950 में। तो वहाँ पर 4 ठो ऑप्शन है सिटीजनशिप पाने के लिए। ए पर्सन हु हैड हिज और हर डोमिसाइल इन इंडिया एंड also fulfilled any one of the 3 conditions. If she was born in India, or if either of his her parents was born in India, or if she has been ordinarily resident in India for 5 years, immediately before the commencement of the constitution became a citizen. सिटीजनशिप पाने के लिए उसका कोई भी यहाँ पर पैदा हुआ होगा पेरेंट्स, और वो नहीं तो पैदा हुआ होगा, और उसका घर रेसिडेंट यहाँ पर होता होगा। ये 3 ठो कंडीशन के आधार पर एक आदमी सिटीजन हो सकता है। ए पर्सन हु माइग्रेटेड टू इंडिया, जो माइग्रेटेड बाहर देश से आए हैं, माइग्रेटेड टू इंडिया फ्रॉम पाकिस्तान बिकेम एन इंडियन सिटीजन if he, she or either of their parents of any of their grandparents was born in undivided India and also fulfilled any one of the 2 conditions. In case he, she migrated to India before July 1948, वो माइग्रेट किया था इंडिया को बिफोर जुलाई 1948. She had been ordinarily resident in India since the date of his or her migration, or in case she migrated to India or after July 1948, she had registered as a citizen of India, but a person could be so registered only if she had been resident in India for 6 months preceding the date of his her application for registration, और ए पर्सन हु माइग्रेटेड टू पाकिस्तान, जो कि पाकिस्तान को गया होगा, माइग्रेटेड टू पाकिस्तान फ्रॉम इंडिया आफ्टर March 1, 1947, but later returned to India for resettlement, could become an Indian citizen. For this, she had to be resident in India for 6 months, preceding the date of her application for registration. रजिस्ट्रेशन का थ्रू से ए पर्सन हु माइग्रेटेड टू पाकिस्तान, अगर एक पाकिस्तान का गया है फ्रॉम इंडिया आफ्टर मार्च 1 1947, बट लेटर और फिर वो लौट कर चले आया है फॉर रीसेटलमेंट, कुड बिकम एन इंडियन सिटीजन, वो इंडियन सिटीजन हो सकता है. फॉर दिस ही सी हैड टू बी रेसिडेंट इन इंडिया फॉर 6 मंथ, उसके लिए इंडिया में 6 महीना रहना पड़ेगा. प्रेसिडिंग द डेट ऑफ हिज आर एप्लीकेशन फॉर रजिस्ट्रेशन, उसका बाद उसको फॉर्म भरना पड़ेगा रजिस्ट्रेशन के लिए. ए पर्सन हु और एनी ऑफ हुज पेरेंट्स और ग्रैंड पेरेंट्स वॉज बॉर्न in undivided India, but who is ordinarily residing outside India shall become an Indian citizen if he or she has been registered as a citizen of India by the diplomatic or consular representatives of India in the country of his or her residence, whether before or after the commencement of the Constitution. Thus, the provision covers the overseas Indians who may want to acquire Indian citizenship. अगर एक आदमी का पेरेंट्स या ग्रैंड पेरेंट्स जन्म हुआ होता होगा अनडिवाइडेड इंडिया में और वो रहता होगा आउटसाइड इंडिया में, वो भी इंडिया का सिटीजन हो सकता है जब वो रजिस्टर करेगा यहाँ पर. To some of these provisions deal with the citizenship of persons domiciled in India or domiciled in India, persons migrated from Pakistan, persons migrated to Pakistan but later returned, and persons of India origin residing outside India. तो पर्सन डोमिसाइल्ड इन इंडिया, उसका इंटरेस्ट है इंडिया में रहने के लिए. अगर वो पाकिस्तान से आया है और पाकिस्तान को चला गया था, फिर उसको अच्छा नहीं लगा, वो रिटर्न किया यहाँ सेटअप होने के लिए. और पर्सन्स ऑफ इंडिया ओरिजिन रिसाइडिंग, और यहाँ का आदमी बाहर रहा है बिजनेस ये सब के लिए, तो ये प्रोविजन आ सकता है. द अदर कॉन्स्टिट्यूशनल प्रोविजंस विथ रेस्पेक्ट टू द सिटीजनशिप आर एज फॉलोज. No person shall be a citizen of India or be deemed to be citizen of India if she has voluntarily acquired the citizenship of any foreign state. कोई भी a citizen of India deemed to be a citizen if she is voluntarily acquired, वो अगर acquire करेगा सिटीजनशिप के लिए. एवरी पर्सन हु इज और हर डीम्ड टू बी ए सिटीजन ऑफ इंडिया shall continue to be such citizen subject to the provisions of any law made by Parliament. Parliament shall have the power to make any provision with respect to the acquisition and termination of citizenship and all other matters relating to citizenship. Citizenship का रिलेट जो कोई भी रूल वो पार्लियामेंट को अधिकार दिया गया है वो बनाने के लिए. वो सिटीजनशिप का एक्विजिशन भी हो सकता है, टर्मिनेशन भी हो सकता है, उसका पावर पार्लियामेंट को दिया गया है. सिटीजनशिप एक्ट 1955, द सिटीजनशिप एक्ट जो कि 1955 प्रोवाइड्स फॉर एक्विजिशन एंड लॉस ऑफ सिटीजनशिप after the commencement of the Constitution. Originally, the Citizenship Act 1955 also provided for the Commonwealth citizenship, but this provision was repealed by the Citizenship Amendment Act 2003. Acquisition of citizenship. The Citizenship Act of 1955 prescribed 5 ways ऑफ एक्वायरिंग सिटीजनशिप। वो 5 वे बताता है जो कि बर्थ, डिसेंट, रजिस्ट्रेशन, नेचुरलाइजेशन एंड इनकॉर्पोरेशन ऑफ टेरिटोरी। These are the ways for acquiring citizenship. First, by birth. A person born in India on or after January 26, 1950, but before July 1st, 1987, is a citizen of India by birth, irrespective of the nationality of his or her parents. A person born in India on or after July 1st, 1987, but before December 3, 2004, is considered as a citizen of India only if either of his or her parents is a citizen of India at the time of his or her birth. Further, those born in India on or after December 3, 2004 are considered citizens of India only if both of their parents are citizens of India or one of whose parents is a citizen of India and the other is not an illegal migrant at the time of their birth. The children of foreign diplomats posted in India and enemy aliens cannot acquire Indian citizenship by birth. बर्थ थ्रू से सिटीजनशिप हासिल किया जा सकता है जिसका जन्म 26/1950 का बाद होता होगा और बिफोर जुलाई 1, 1987 में हुआ है, वो सिटीजनशिप पाने के लिए हकदार है। देन बाय डिसेंट, a person born outside India on or after January 26, 1950, but before December 10, 1992, is a citizen of India by descent if his or her father was a citizen of India at the time of his birth. जो आउटसाइड रहा है, जो आउटसाइड पैदा हुआ है जनवरी 26, 1950 का बाद और जो दिसंबर 10, 1992 का पहले, उसको सिटीजन ऑफ इंडिया दिया जाएगा बाय डिसेंट इफ हिज हर फादर वाज अ सिटीजन, लेकिन उसका फादर या मदर सिटीजन ऑफ इंडिया होना चाहिए जब वो पैदा हुआ। ए पर्सन बोर्न आउटसाइड इंडिया ऑन और आफ्टर December 10, 1992 is considered as a citizen of India if either of his or her parents is a citizen of India at the time of his or her birth. From December 3rd, 2004 onwards, person born outside India shall not be a citizen of India by descent unless his or her birth is registered an Indian consulate within 1 year of the date of birth when the permission of the central government. After the expiry of the said period, an application for registration of the birth of a minor child to an Indian consult shall be accompanied by an undertaking in writing from the parents of such minor child that he or she doesn't hold the passport of another country. फर्दर ए माइनर हु इज सिटीजन ऑफ इंडिया, जो कि एक सिटीजन ऑफ इंडिया है बाय वर्च्यू ऑफ डिसेंट एंड इज आल्सो ए सिटीजन ऑफ एनी अदर कंट्री shall cease to be a citizen of India if he or she doesn't renounce the citizenship of nationality of another country within 6 months of his or her attaining full age. और एक बाय रजिस्ट्रेशन के थ्रू से हो सकता है। द सेंट्रल गवर्नमेंट में रजिस्टर एज ए सिटीजन ऑफ इंडिया एनी पर्सन नॉट बीइंग एन इलीगल माइग्रेंट इफ ही और सी बिलोंग्स टू एनी ऑफ द फॉलोइंग कैटेगरीज: a person of Indian origin who is ordinarily resident in India for 7 years before making an application for registration. ए पर्सन ऑफ इंडियन ओरिजिन, जो कि एक इंडियन ओरिजिन का पर्सन, हु इज ऑर्डिनरीली रेसिडेंट इन एनी कंट्री और प्लेस आउटसाइड अनडिवाइडेड इंडिया। ए पर्सन हु इज मैरिड टू ए सिटीजन ऑफ इंडिया, जो कि सिटीजन ऑफ इंडिया का साथ मैरिज करने के बाद एंड इज ऑर्डिनरीली रेसिडेंट इन इंडिया फॉर 7 years, और वो 7 साल रहने के बाद उसको इंडिया का सिटीजन मिल जाता है। बिफोर मेकिंग एन एप्लीकेशन फॉर रजिस्ट्रेशन, माइनर चिल्ड्रेन ऑफ पर्सन हु आर citizens of India, a person of full age and capacity whose parents are registered as citizens of India, a person of full age and capacity who or either of his or her parents was earlier citizen of independent India and is ordinarily resident in India, वो रहते हैं for 12 months immediately before making an application for registration. A person of full age and capacity who has been registered as an overseas citizen of India, card holder for 5 years, and who is ordinarily resident in India for 12 months before making an application for registration. A person shall be deemed to be of Indian origin if he or she or either of their parents was born in undivided India or in such other territory which became part of India, जो कि part of India हो after the August 15, 1947. All the above categories of persons must take an oath of allegiance before they are registered as citizen of India. After that naturalization, the central government may grant a certificate of naturalization to any person not being an illegal migrant if he or she possesses the following qualification. यहाँ पर क्वालिफिकेशन दिया गया है जो कि दैट ही और सी is not a subject or citizen of any country where citizens of India are prevented from becoming subjects or citizens of that country by naturalization. जो कि इंडिया में रहा है उसको सिटीजनशिप मिल जाएगा. That if he or she is a citizen of any country, they undertake to renounce the citizenship of that country in the event of their application for Indian citizenship being accepted. That he or she has either resided in India or been in the service of a government in India or partly the one and partly the other throughout the period of 12 months immediately preceding the date of the application. That during the 14 years immediately preceding the said period of 12 months, he or she has either resided in India or been in the service of a government in India. वो यहाँ पर रह सकता है और नहीं तो गवर्नमेंट सर्विस किया होगा. For period amounting in the aggregate to not less than 11 years. However, the Citizenship Act 2019 has reduced this aggregate period of residence or service of government in India to not less than 5 years for the person belonging to Hindu, Sikh, Buddhist, Jain, Parsi or Christian community in Afghanistan, Bangladesh or Pakistan. That he or she of good character, वो good character होता होगा. That he or she has an adequate knowledge of a language specified in the 8th schedule to the Constitution. 8th शेड्यूल में जोन सा लैंग्वेज ऑफिशियल लैंग्वेज है वहीं से एक लैंग्वेज को वो जानता होगा. दैट इन द इवेंट ऑफ ए सर्टिफिकेट ऑफ नेचुरलाइजेशन बीइंग ग्रांटेड टू हिम और हर, he she intends to reside in India or to enter into or continue in service under a government in India or under an international organization of which India is a member of under a society, company or body of persons established in India. However, the government of India may waive all or any of the above conditions for naturalization in the case of a person who has rendered distinguished service to the science, philosophy, art, literature, world peace of human progress. Every naturalized citizen must take an oath of allegiance to the Constitution of India by incorporation of territory. If any foreign territory becomes a part of India, अगर कोई बाहर का कंट्री एक पार्ट ऑफ इंडिया है, the government of India specifies the persons who among the people of the territory shall be the citizen of India. Such persons become the citizen of India from the notified date. For example, when Pondicherry became a part of India, the government of India issued the citizenship Jonsa Pondicherry Order 1962 under the Citizenship Act 1955. उसका बाद स्पेशल प्रोविजंस एज टू सिटीजनशिप ऑफ पर्सन्स कवर्ड बाय आसाम एक्ट. The Citizenship Amendment Act Jonsa 1985 added the following special provisions as to citizenship of persons covered the Assam Accord which related to the foreigners issue. All persons of India origin who came to Assam, जो कि आसाम को आया होगा before January 1st 1966 from Bangladesh and who have been ordinarily residents in Assam since the date of their entry into Assam shall be deemed to be citizen of India as from January 1, 1966. Every person of Indian origin who came to Assam on or after January 1st, 1966, but before March 25, 1971 from Bangladesh and who has been ordinarily resident in Assam, वो आसाम में रहता होगा since the date of his her entry to Assam and who has been detected to be a foreigner shall register himself. Such a registered person shall be deemed to be a citizen of India for all purposes as from the date of expiry of a period of 10 years from the date of detection as a foreigner, but in the intervening period of 10 years she shall have the same rights and obligations as a citizen of India, excepting the right to vote. Special provisions to citizenship of persons migrated from Afghanistan, जो कि अफगानिस्तान, बांग्लादेश और पाकिस्तान से आए हैं. The Citizenship Amendment Act 2019 added the following special provisions as to the citizenship of migrants belonging to Hindu, Sikh, Buddhist, Jain, Parsi or Christian communities from Afghanistan, Bangladesh or Pakistan who entered into India on or before December 31st, 2014 and who have been exempted from the adverse penal consequence of the Passport Entry into India Act 1920 and the Foreigners Act 1946. The central government may grant a certificate of registration, वो grant कर सकता है certificate of registration और certificate of naturalization to such a person on the fulfillment of the specified conditions for registration or qualification for naturalization. Such a person who has been granted the certificate of registration or certificate of naturalization shall be deemed to be a citizen of India from the date of his or her entry into India. Any proceedings pending against such a person in respect of illegal migration of citizenship shall stand awaited on conferment of citizenship to him. These special provisions are not applicable टू ट्राइबल एरियाज, ये ट्राइबल एरियाज के लिए एप्लीकेबल नहीं है, ऑफ आसाम, मेघालय, मिजोरम और त्रिपुरा एज इंक्लूडेड in the sixth schedule to the constitution, and the area covered under the inner line notified under the Bengal Eastern Frontier Regulation 1873 before enactment of the Citizenship Act 2019. The migrants belong into the Hindu, Sikh, Buddhist, Jain, Parsi or Christian communities from Afghanistan, Bangladesh और पाकिस्तान who entered into India, जो कि इंडिया में एंटर्ड किए without valid passport and other travel documents, or if the validity of their passport and other documents had expired, were regarded as illegal migrants and were ineligible to apply for Indian citizenship under the provisions of the Citizenship Act 1955. वो सिटीजनशिप पाने के लिए रजिस्ट्रेशन कर नहीं पाएंगे, क्योंकि उन लोगों का डॉक्यूमेंट सही अगर नहीं है तो उन लोगों को सिटीजनशिप मिलेगा नहीं. In 2015, the central government exempted the said migrants from the adverse penal consequence of the Passport Entry into India Act 1920 and the Foreigners Act 1946. Subsequently, in 2016, central government also made them eligible for long-term visa to stay in India. With the enactment of the Citizenship Amendment Act, जो कि 2019 में पास किया गया था, the said migrants became eligible for Indian citizenship. This act came into force. वो फोर्स हुआ जनवरी 10, 2020. लॉस ऑफ सिटीजनशिप, कैसे सिटीजनशिप लॉस होता है, कैसे उसका कट जाता है. द सिटीजनशिप एक्ट 1955 prescribes three ways of losing citizenship, whether acquired under the act or prior to it under the constitution: renunciation, termination and deprivation. Renunciation: any citizen of India of full age and capacity can make a declaration renouncing his or her Indian citizenship. Upon the registration of that declaration, that person ceases to be citizen of India. However, if such declaration is made during a war in which India is engaged, its registration shall be withheld by the central government. Further, when a person renounces his or her Indian citizenship, every minor child of that person also loses Indian citizenship. However, when such a child attains the age of 18, may resume Indian citizenship, और एक टर्मिनेट कर भी लॉस होता है. When an Indian citizen voluntarily, consciously, knowingly and without duress, undue influence or compulsion acquires the citizenship of another country, his or her Indian citizenship automatically terminates. This provision, however, does not apply during war in which India is engaged. By deprivation, it is compulsory termination of Indian citizenship by the central government if the citizen has obtained the citizenship by fraud, the citizen has shown disloyalty, वो disloyalty दिखाता है, to the Constitution of India, the citizen has unlawfully traded or communicated with the enemy during a war, the citizen has within 5 years after registration or naturalization been imprisoned in any country for 2 years, and the citizen has been ordinarily resident out of India for 7 years continuously. Then overseas citizenship of India. In September 2000, the government of India Ministry of External Affairs had set up a high-level committee on the Indian dis, uh, diaspora under the chairmanship of L.M. Singhvi. The mandate of the committee was to conduct a comprehensive study of the global Indian diaspora and to recommend measures for a constructive relationship with them. ये 2000 का है, गवर्नमेंट ऑफ इंडिया जो कि सेटअप किया था हाई लेवल कमिटी ऑन द इंडियन डिस्पोरा अंडर चेयरमैनशिप. किसका चेयरमैनशिप का अंडर में एल.एम. सिंघवी. और वो उसका ऑब्जेक्टिव था टू कंडक्ट ए कॉम्प्रिहेंसिव स्टडी ऑफ द ग्लोबल इंडियन डिस्पोरा and to recommend measures for a constructive relationship with them. The committee submitted its report. वो report submit किया था जनवरी 2002. It recommended the amendment of the Citizenship Act 1955 to provide for grant of dual citizenship to the persons of Indian origin belonging to certain specified countries. Accordingly, the Citizenship Act 2003 made provision for acquisition of overseas citizenship India by the POs of 16 specified countries other than Pakistan and Bangladesh. It also omitted all provisions recognizing or relating to the Commonwealth citizenship from the Principal Act. Later, the Citizenship Amendment Act 2005 expanded the scope. वो expand करता है scope of grant OCI for PIOs of all countries except Pakistan and Bangladesh, as long as their home countries allow dual citizenship under their local laws. It must be noted here that the OCI is not actually a dual citizenship, as the Indian Constitution forbids dual citizenship or dual nationality. Again, the Citizenship Amendment Act, जो कि आता है 2015 में, has modified the provisions pertaining to the OCI in the Principal Act. It has introduced a new scheme, जो कि बोला जाता है Overseas Citizen of Indian Card Holder, by merging the PIO card scheme and OCI card scheme. The PIO card scheme was introduced. वो introduced होता है 19th August 2002 को, and thereafter the OCI card scheme was introduced December 2005. Both the schemes were running in parallel, even though the OCI card scheme had become more popular. This was causing unnecessary confusion in the minds of applications. ये confusion हुआ, keeping in view some problems being faced by applicants and to provide enhanced facilities to them. The Government of India decided to formulate one single scheme after merging the PIO and OCI schemes containing positive attributes both. Hence, for achieving these objectives, वो अचीव करने के बाद the Citizenship Amendment Act 2015 was enacted. The PIO scheme was rescinded January 9, 2015, and it was also notified that all existing PIO card holders shall be deemed to be OCI card holders January 9, 2015. The Citizenship Amendment Act जो कि 2015 में हुआ था, वो रिप्लेस्ड हुआ nomenclature of overseas citizen of India with that overseas citizen of India card holders and made the following provisions in the Principal Act. क्या क्या provision रहा? Registration of overseas citizens ऑफ इंडियन कार्ड होल्डर्स किस तरह रजिस्ट्रेशन किया जाएगा? The central government may register as an overseas citizens of India cardholders any person of full age and capacity who is citizen of another country but was a citizen of India at the time of or at any time after the commencement of the constitution, or who is citizen of another country but was eligible to become a citizen of India at the time of the commencement of the constitution, जो कि सिटीजन है अदर कंट्री का लेकिन वो एलिजिबल है जो वो कॉन्स्टिट्यूशन जब शुरुआत हुआ था तब वो भी हो सकता है. हु इज सिटीजन ऑफ अनदर कंट्री बट बिलोंग टू ए टेरिटोरी दैट became part of India after the 15th August 1947, or who is a child or grandchild or a great grandchild of such a citizen, or a person who is minor child of a person mentioned above clause A, or a person who is minor child and whose both parents are citizens of India, or one of the parents is a citizen of India, spouse of foreign origin of a citizen of India, or spouse of foreign origin of an overseas citizen of India cardholder and whose marriage has been registered and subsisted for a continuous period of not less than 2 years immediately preceding the presentation of the application, but a person who or either of whose parents or grandparents or great grandparents each or had been a citizen of जो कि citizen होता होगा पाकिस्तान, बांग्लादेश or such other country as the central government may specify shall not be eligible for registration as an overseas citizen of India cardholder. Then conferment of rights on overseas citizen of India cardholder. An overseas citizen of India cardholder should be entitled to such rights as the central government may specify in this behalf. These are mentioned. An overseas citizen of India cardholder shall not be entitled to the following rights, which are conferred on a citizen of India. His or she shall not be entitled to the rights to equality of opportunity in matters of public employment, जो कि आर्टिकल 16 में है. He she shall not be eligible for election as president, article 58. He or she shall not be eligible for election of vice president, article 66. He she shall not be eligible for appointment as a judge of the Supreme Court. He or she shall not be eligible for appointment as a judge of the High Courts. He she shall not be entitled for registration as a voter. He or she shall not be eligible for being a member of the House of the People of the Council of States. He or she shall not be eligible for being a member of the State Legislative Assembly or State Legislative Council. He or she shall not be eligible for appointment to public service and post in connection with affairs of the Union of any state except for appointment in such services and post as the central government may specify. Then renunciation of overseas citizen of India card. Any overseas citizen of Indian card holders can make a declaration renouncing his or her overseas citizen of India cardholder status. After that declaration is registered by the central government, such a person ceases to be an overseas citizen of Indian cardholders. Where a person ceases to be an overseas citizen of India cardholder, the spouse of foreign origin, जो एक आदमी शादी किया है लेकिन वो उसका वाइफ दूसरा कंट्री का है, of that person who has obtained overseas citizens of Indian card, and every minor child of that person registered as an overseas citizen of India cardholders also cease to be an overseas citizen of Indian cardholder. Then cancellation registration as overseas citizens of Indian card holders, the central government may cancel, वो cancel कर सकता है the registration of a person as an overseas citizen of Indian card holders if it is satisfied that the registration as an overseas citizen of India card holders was obtained by means of fraud, false representation, or the concealment of any material fact. An overseas citizen of India cardholder has shown disaffection towards the Constitution of India, or the overseas citizen of India cardholders has during any war in which India may be engaged, unlawfully traded or communicated with an enemy. वो लोग enemy के साथ भी communicate करते हैं. The overseas citizen of India card holder has within 5 years after resignation been sentenced to imprisonment for a term of not less than 2 years. The overseas citizen of India card holders has violated the provisions of the Citizenship Act जो सा 1955 में हुआ था or the provisions of any other law as may be specified by the central government. This provision was added, वो added किया गया Citizenship Act को 2019 में. It is necessary so to do in the interest of the sovereignty and integrity of India, the security of India, friendly relations of India with any foreign country, or in the interest of the general public, or the marriage of an overseas citizen of India cardholders has been dissolved by a competent court of law or otherwise, or has not been dissolved, but during the subsistence of such marriage, he or she has solemnized marriage with any other person. However, before the cancellation of his or her registration as an overseas citizen of India cardholder, she will be given a reasonable opportunity of being heard. This provision was also added by the Citizenship Amendment Act 2019. यहाँ पर दिया गया है NRI मीन नॉन रेसिडेंशियल इंडियन, PIO एंड OCI कार्ड होल्डर्स यहाँ पर टेबल में दिया गया है जो एलिमेंट्स ऑफ कंपैरिजन नॉन रेसिडेंट इंडियन पर्सन्स ऑफ बीइंग persons of Indian origin, PIO, overseas citizens of India, OCI, card holders. An Indian citizen who is ordinarily residing outside India and holds an Indian passport, और persons of Indian origin बोला जाता है person who or whose any of ancestors, उसका ग्रैंड पेरेंट्स हो सकते हैं, और जो कोई भी हो सकता है उसका फैमिली का, was an Indian national and who is personally holding another country's citizenship, nationality, she is holding foreign passport. Overseas citizens, a person registered as overseas citizen of India, cardholder under the Citizenship Act 1955. Thank you.